Okay.
There you go.
Okay, so back on the record, outside the presence of the jury, counsels. Mr. Odou, I see you standing, so do you want to address your issue? Go ahead, please.
Yes, Your Honor, Joel Odou for the real water defendants. First, I wanted to alert the court, Mr. Freeman is covering hearing another matter that's why he's not here. We're prepared to proceed.
Oh, okay. Oh, you're proceeding because you're taking this issue on, correct?
Yes.
Okay, go ahead.
Yes, Your Honor, I'll be taking this issue on, also covering the next few witnesses. It will not impact us in any way. Thank you, Your Honor. Your Honor, as I'm sure the court recalls, we have Mr. Wadkins on the witness list. He was the subject of a number of motions on the 3, 8, and 9. And we have reviewed those at the lunch break, and I just wanted to bring to the court's attention the issue and then flesh it out with the court's permission.
Go ahead, please.
So, Your Honor, Mr. Wadkins is a plaintiff in another case. Therefore, that touches on motion limit number 3. The court deferred action on other claims in motion in limine number 3. Mr. Wadkins also had a written customer complaint from his wife, not from him. And I have Mr. Zamora prepared to show that to the court because I believe it will be at the issue. But the customer complaint was from Jerry Wadkins to Real Water. It's proposed exhibit 71. And Mr. Zamora has put it before the court, and I'll talk about that in just one second. The other motion in limine that is applicable here is motion in limine number 8 to limit lay testimony, which is granted in part and denied in part. The reason why motion in limine number 8 is applicable is because it's a question of the medical advice provided to Jerry Watkins and Mr. Watkins in particular. Now I can address proposed exhibit 71 if that's okay. I'd like Mr. Zamora to put it up. So on the second page near the top, there's an ongoing dispute. The email's about an ongoing dispute about returning the water cooler. On page 2 of proposed exhibit 71, Mr. Watkins advises, my husband has been in the hospital for 2 weeks and the doctors want him to stop drinking alkaline water. I can provide that information if you want to see. I'm lying about that as well. I don't need this BS. Your Honor, the proposed testimony from Mr. Watkins is that he was in the hospital because of drinking real water. He didn't learn, and we know this from his trial testimony and from his deposition, or he knows this from his trial testimony in another matter. He didn't learn that real water had made him sick until after it was on the news. So we have a number of objections to his testimony. One, there's not a written customer complaint about real water. As Exhibit 71 shows, it's a customer complaint that the husband has been told not to drink alkaline water. That's the first issue, Your Honor. Alkaline, some people do not tolerate alkaline water. That's not disputed. In this particular instance, the plaintiffs want to draw the connection, or wanted real water, more likely to draw the connection that their husband was sick in 2018 because he drank real water. Certainly, that's a reasonable inference that the jury may draw, and the jury may agree with the plaintiffs, and that's the danger of prejudice. The other part of this is, obviously, real water has admitted liabilities. This, I would assume the plaintiffs will argue goes to punitive damage as well. Mr. Watkins has his own case. Mr. Watkins will provide this in his own case, and presumably, whoever the judge is in that case, I don't remember off the top of my head, will make a ruling, and if he's permitted to testify, it will go to punitive damages in Mr. Watkins' case. So that would yet be another reason to exclude it. So we wanted to bring this outside the court, outside the presence of the jury, because it's really the sole reason to call Mr. Watkins. We wanted to alert the court to this issue. We don't think he can testify as to whatever a doctor told him and provide lay testimony about his injury. We don't think that it's appropriate to allow this hearsay statement in from the wife that the husband has been in the hospital and told not to drink alkaline water because of a reliability issue. Yes, it is a business record of Real Water. We will say that right up front. But we think it's prejudicial, and its prejudicial value outweighs its probative nature.
So, first question. So, not knowing the full scope of which ones you're going to, what is recollection from the time of the motions that the issue was notice? One of the things that counsels for plaintiffs said was the reason why, other customer complaints was the notice component to go to the punitive damages aspect.
That's right.
So, how does that notice component that was raised earlier address the objections that you're raising with regards to Mr. Wadkins and in addition, Exhibit 70, proposed Exhibit 71?
Thank you, Your Honor. 2 points on that. One, the proposed Exhibit 71 does not go to notice because it talks about alkaline water. It doesn't say that he is in the hospital because he drank real water. That was something that was learned later. So when the Wadkins learned that real water was contaminated and made him sick, that occurred after this email in 2018. That occurred in 2020, 2021, whenever they saw the news. So their knowledge as to what made him sick in 2021 cannot be given as notice in 2018. The court may have a question, but I'll pause.
I do, because, right, they were saying notice to real water was what was articulated to the court, right?
That's right.
Real water, and I'm going back because this was quoted back at the time the motion was eliminated.
That's right.
And I'm paraphrasing, but that real water was on notice of customer complaints. And so while we went into the fan issue and not giving person's dog,
Right.
et cetera, the court did defer because it needed to hear these one by one, how they address the notice issue. So are you, and that's why I'm having a little bit of a challenge here, is because I appreciate you're saying he may not have known, and he testified that he does not know until 2020, for purposes of my question, I don't assume that's accurate, right? Isn't the court to be looking at this in the eyes of real water and whether or not this notification email, what was an email, right?
Yes.
This email, other than it came from the wife, not the husband, but what was the impact of this email as far as putting real water on notice as a maker of alkaline water, that it should be doing something? That was kind of, I'm paraphrasing what was articulated to the court at the time of motions limited, so.
And the court is accurate. I agree with what the court said, and I will address that.
Sure.
So, Your Honor, that is the key issue because it's alkaline water. There was no claim, there is no claim that the plaintiffs in this case are sick because they drink alkaline water. That is not an issue in this case. It's not a claim in this case. So if the claim was, you know, we're allergic, like it was a peanut claim, we're allergic to peanuts, you have peanuts, your products, so forth. That's not the claim here. The claim here is the water was contaminated with hydrazine. The fact that a person had an adverse reaction to alkaline water does not put real water on notice that the water is contaminated. It puts real water on notice that a person had an issue with alkaline water. Those are two different things. I believe the plaintiff will say they're the same thing, and good for them. Because that's the next part of the problem, because the plaintiff will say it's the same thing, that it puts them on notice, then the prejudicial nature of this outweighs its probative value. In other words, from the eyes of real water, they get a complaint that somebody can't tolerate alkaline water, they want to return their jug, they want to return their cooler. There's an argument about, the refund for the cooler. That's the context that real water received this complaint, which was, hey, I want a refund for my cooler rental and take the cooler back because my husband can't drink alkaline water. That is exactly what this says. Plaintiff wants the jury to then conclude, no, that's not what this says. This is a complaint about a poison in the water, and it should put real water on notice. It does not go to notice of hydrazine, Your Honor, and its prejudicial nature outweighs any probative value. The other part of notice that we are arguing, Your Honor, is it may go to notice in Mr. Watkins' case. It may go to punitive damages in Mr. Watkins' case. It shouldn't be offered in this case. That is a double hit of the punitive nature. In other words, if the jury wants to punish real water for not responding to this email, The jury will do that in Mr. Watkins' case.
Appreciate it, thanks. ETT?
Taking, we join in the,
You're-
I'm sorry.
Sorry.
Ms.
Who
Rojas.
Who's taking this?
I got this, Your Honor, thank you. Valerie Rojas for ETT, I apologize for the confusion.
No worries.
ETT objects to Mr. Watkins' testimony, and I refer the court back to motion eliminating number 11 and 12, as well as our joinders to the real water motions eliminated concerning the prior customer complaints and lay opinion testimony. Our position is slightly different, Your Honor, in that ETT did not receive notice of this complaint and would not expect to. Mr. Watkins was consuming the 5-gallon jugs of water. And if you read this email in context, it's pretty much about a billing issue with the exception of this paragraph here concerning the husband, which states, "My husband has been in the hospital for 2 weeks and the doctor wants him to stop drinking alkaline water." I can provide that information if you want to see if I'm lying about that as well. I don't need this BS info. ETT is not in the lawsuit involving Mr. Watkins, Your Honor, so I don't have privy to his medical records. I'm left to speculate and guess as to what he was actually in the hospital for. There seems to be an implication that alkaline water had something to do with it. And we're objecting for a number of reasons. Number one, it's irrelevant when it comes to ETT. It certainly does not go to notice. It's unduly prejudicial because the jury is going to be confused and thinking notice to real water is somehow notice to ETT. And that's why we keep hearing that ETT was a marketing arm and evidence of trying to establish that. If the jury sees this email, number one, it's hearsay. It's Ms. Watkins, it's not Mr. Watkins, relaying his own condition. She's simply relaying what her doctor, her husband's doctor, presumably told her or her husband concerning alkaline water. And that's irrelevant when it comes to ETT. The email here is hearsay, the statements in it is hearsay, and what Mr. Watkins is going to talk about on the stand is concerning customer complaints. As Real Water pointed out, he has his own lawsuit, which is more properly proper forum for his testimony, Your Honor. ETT can be punished for customer complaint we didn't know about. So at the very least, even if it did come in for Real Water, we would ask for a limiting instruction as an alternative. But in the first instance, we don't believe it should be admitted at all.
Okay, appreciate it. Mr. Kemp, looks like you're taking this one for, right? As you all know, I'm handling this because this was a specific deferral and the motion is eliminated, so I understand.
I don't want to go through the cases, that there's a long line of bad cases saying prior customer complaints are admissible for notice of potential dangerous and defective condition. So it comes in as notice of potential dangerous defective condition. If you recall, when we argued this, we talked about, I think, at least 6 punitive damages cases that said 5 complaints, 6 complaints, 3 complaints, 2 complaints, 1 complaint are sufficient to show conscious disregard for punitive purposes. So this is the first of what's going to be approximately 20 complaints. So it's not hearsay in the first case because we're not offering it to prove the matter asserted, which is that Mr. Watkins got sick from drinking red water. We're offering it as notice of potentially dangerous and defective condition. And that's what all the cases say. None of the cases, and I can go through Guinness and all of them if you want, Your Honor, but none of the cases say that you have to bring in an expert witness for the person who filed the complaint. None of the cases say that you have to prove medical causation as a condition for admission because they're being admitted as notice. And so that is the relevance of these cases. That's why this document is relevant. With regard to foundation, Mr. Odou admitted it's a business record. That satisfies the foundation objection. I don't have to bring in the person that wrote the email. This is a real water business record. That meets the foundation because foundation is completely different than relevance. Okay, I just have to show it's relevant. And I don't really understand his argument that it's a complaint about alkaline water in general, as opposed to a complaint about real water, because the statement is in the last part of a 5-page, I think 4 or 5-page email, where there's a series of emails about the real water dispenser, the 5-gallon jugs. So it's clearly about real water. It should use the term alkaline water, not real water. So for those reasons, it comes in as to notice, Your Honor. With regard to Terrible's objection, if the document is admissible, it's admissible, Your Honor. They can point out, and it was asked at the last trial whether or not it was 5-gallon jugs he was drinking or retail bottles. They can point that out, and they can also point out that this went to real water, it didn't go to Terrible's. And they can argue that. And this witness will freely admit that, and I'll admit that on the record. This is offered as notice to real water. It's not offered as notice to Terrible Herbst. And so for those reasons, Your Honor, there's really no valid objection to this, because if you cannot get a document in from a customer complaining that the product put him in a hospital and his doctor attributed his hospitalization to the product, there's no more point of notice possible of that. There's no possible notice that is greater than that, Your Honor. And with regards to this statement that, well, he can admit it in his case, you know, that brings up the other issue. I wasn't going to bring up the fact that he's a plaintiff. If they want to bring it up for bias, that's fine with me, Your Honor. But it doesn't have anything to do, just because it's noticed in different cases. It was admitted in Gallagher, it was noticed in Gallagher, it's noticed in this case, it's going to be noticed in the next case. It is noticed to the manufacturer in every single case. It's just not noticed in the case of the person who wrote the complaint. Because if that was the standard, you would never have a prior customer complaint admitted as notice. And I go back to the Guinness versus Mapes case. Okay, they took 36 other doors. They weren't in the same door. And those were admissible as notice of potential dangerous and defective condition. And then we had the Robinson case. Those were other accidents involving other type of, it was some kind of, it was something to do with a grocery store, or back end of a grocery store. It was a guard, okay? So other complaints of other machines were offered as notice. Not even the same machine, those were offered as notice. Clearly those involved other people, Your Honor. So this is why the evidence comes in for notice, and this objection that it's not relevant is just not well taken into the case law.
I got a question. Addressing Mr. Odou's point, that the court has to look at it in the eyes of how real water would look at it, right?
Right.
It was a dispute basically over a cooler, and that there was a general statement from the doctor that her husband should not drink alkaline water rather than should not drink real water, and not knowing at that time how many different types of alkaline water he may or may not have been drinking, etc. You want to address that? I mean,
Your Honor, the first 5 emails in this chain talk about the real water in the real water dispenser. It's only this last email that says alkaline water. So we're to assume that that's some different alkaline water?
No, I'm sorry. The reason I'm stopping is because I think Mr. Odou's statement to the court was that
His statement was that it's not a formal customer complaint.
like
It's
of a
still,
real water product. It's just the doctor says he can't drink alkaline water as her reasoning why she gets to return the cooler for free and get a refund.
real water is alkaline water. There's no dispute about that. There's no dispute that he was drinking 5-gallon jugs, Your Honor. That is the alkaline water that is being discussed in this email. To suggest that this is some other alkaline water we don't know about, there's absolutely no evidence for that, Your Honor. And it doesn't matter, because it's notice of potential dangerous and defective condition. So I talked about Robinson, other machines, okay? Notice of defects, the same kind of defect in an analogous machine, that comes in to prove notice of a potential dangerous and defective condition. It doesn't matter whether it's real water. In this case, it was clearly real water, but it doesn't matter.
So walk me through what else Wadkins, since this issue's gonna come up. Are we
He's
just
gonna say-
talking Exhibit 71, or is he gonna start telling his tales of woes and his description?
He's going to say that he drank real water. He went to the hospital. He was in the hospital for about a week. That's pretty much it. And if they want to get into his case that's filed, that's fair game for them. I'm not going to get into trial.
So is he intending to try and talk about symptoms or anything like that, or how bad he felt?
He's going to, well, he's got to say why he was in the hospital. If you want me to limit that, I'd be more than happy to do so.
That's what I need to discuss, because what the concern is this is not his trial. And it's not
Right,
for
we
him
don't,
to-
I don't understand, I don't plan, you know, last trial he was on for 12 minutes, and I think it's probably less this time. If you want me to just say he was in the hospital, I'll be more than happy to say that.
Okay, let me circle back to everybody else. Let me give you all where I'm going for the court's inclination, then you can want to address whatever you wish to address. Here's where the court's inclined. The court's inclined that he's not going to be precluded from coming onto the stand, because I haven't heard something that would preclude him from coming onto the stand. Would he be able to address that he drank real water and that he was hospitalized and his wife sent this email that's true and accurate, okay? And that his doctor told him not to drink alkaline water, that is going to be fine and appropriate. Because realistically, what I see is, from real water standpoint, real water can address the fact that, what, did you know at this time it was real water, were you drinking other alkaline waters? Once again, here's where the court doesn't have the benefit, I obviously don't know what he testified to in the last case, okay? We don't know what his depot said, because y'all haven't presented that, he just presented a more narrow issue. But he's not gonna be able to go into saying his symptoms, his diagnosis, because none of that is back in 2018. He can't say how he felt, how horrible he felt, or all the different things, or if he wished things on people or didn't wish things on people, okay? Because that would be all impermissible and outside for purpose of notice. But for the limited purpose of notice, since it can be argued that in real water's view, this would not be notice of the issues related to real water versus being, if they're contending it's a cooler rental issue, that's all appropriate. So I don't see it's more prejudicial than probative because of that aspect. With regards to Terrible Herbst, where I'm going with that one is, I think you have the same opportunity to inquire on him. Did he buy anything from Terrible Herbst? If you want to open that, or you could say, look, this is only 5-gallon jugs, this was only home delivery, because, I mean, just like you asked another witness, you never drank anything, from Terrible Herbst. I think that minimizes or eliminates any issues with regards to Terrible Herbst, for the confusion between it and real water. Now, with regards to the court applying that it's notice to Terrible Herbst, that's not anything that's being asked at this juncture, okay? That can easily be fleshed out with regards to his wife wrote the email to whom, okay? And realistically, you can almost flesh it out in a lot of different ways. It's experienced counsel to show that it has no ties to Terrible Herbst, and if you think that there's an issue, you can ask the court to approach, or you can ask the court to do it outside the presence of the jury if there's something else that needs to be done. I'd have to hear the question and answer the testimony first to see if there's some issue with regards there too. So that's the court's inclination, and as far as you can't go into his damages, et cetera, or his anything more of a medical diagnosis other than what's really limited in the Exhibit 71, which is he was in the hospital and was told not to drink alkaline water. Counsel, Mr. Odou, feel free to respond. That's just like the court's inclination, like what I've heard so far, but you can go around everyone if they want.
Thank you, Your Honor. Joel Odou for Real Water. I would like to respond, Your Honor. Mr. Zamora, if you could propose Exhibit 71 up and we'll start to talk. I want to make it clear for the record that we are not saying that he's talking about another kind of water.
I didn't understand it. I understood that you were saying a reasonable person reviewing this would not think it's an issue that there's something in the product that smells, tastes funny, that it's a bad product, that basically it's a cooler rental issue, and her reasoning for cooler rental return is the fact that it is. That's your argument, and plaintiffs have a very different argument.
That's right, Your Honor. So it has, we're not trying to conflate the issue and talk about other alkaline waters. That's not the issue. The issue is the cases cited by the plaintiffs. The Mays case involved a door. The Robinson case involved a guard on some type of machine. Other machines were allowed in. The point of those cases were, Your Honor, that a lay person could see the danger and appreciate the danger. Again, we're looking at this at the eyes through real water. Real water are not doctors, Your Honor. And so when somebody is complaining about a cooler rental and they want a refund on a cooler rental, and they say that their husband has been told not to drink alkaline water, that's the eyes of real water. Real water is looking at it through, we have a customer complaint, they want to cancel their real water subscription. They say that the husband has been told not to drink alkaline water. That's the reason they're canceling the complaint. They're not doctors. They're not going to go, oh, well, that means there's something wrong with our water. That's the notice that the plaintiffs are trying to achieve here, Your Honor, and that's the difference between the Mays case and the Robinson case. a reasonable person in the Myles or Robinson situation can look at a door and go, oh, I see, they're complaining about this danger, this specific danger in this door. Or in the Robinson case, I can see a reasonable person should have been able to see there's a complaint about this aspect of the machine. Here, a reasonable person is going to say, oh, this person has been told not to drink alkaline water. A reasonable person isn't going to then jump to the conclusion, hey, there's something in our water that's making people sick. And, Your Honor, that's where we believe there's a distinction. The complaint says what it says, but from a reasonable standpoint, the question is, and this is, we appreciate it's a hard call for the court, right? The jury interprets the facts, the court interprets the law. We believe this is, the court calls balls and strikes. We think this is a ball. We think this is something that is so prejudicial that it should not be a strike, it should not be put before the jury, because a reasonable person is going to read this email and understand this is a complaint about the inability of somebody to drink alkaline water. And that's why we think this situation is distinguishable from Myles and Robinson and the other cases cited by the court in its order.
I appreciate it. Thanks so much. ETG, you need another minute or two? Then I just want a minute or two if you want it. You do all recall telling the court that you really didn't think you were going to need anything, which is why I only had you come back 5 minutes before the jury, right?
Sorry.
Okay.
Thank you, Your Honor. Valerie will have to repeat. I'll be brief, Your Honor. And as to the unduly prejudicial, we just heard testimony concerning customer complaints. And what we're concerned about is we cannot unring the bell. Once we let this in, there's going to be a clear confusion on the jury's part. Complaints made to low water should somehow have been discovered by ETT prior to this date. And I know I can cross-examine the witness on this, but it just seems that we're going to keep coming up against the same issue with Theodore 20 or whatever customer complaints counsel referred to. And that's why we're making our objections on this. Thank you.
Issue by issue before the court. I appreciate it. Okay, Councilor Plano. Another minute? Pardon?
Nothing further.
Okay. Court turns its inclination into a ruling. I'm going to add to it that with regards to whether ET&T and or Real Water want to address the fact that he is a plaintiff, then that could come in for bias and credibility. Just watch out. Here, I'll cite your Cox case back, right? For challenges for extrinsic things of credibility, but okay. So obviously you need to be cognizant of that, but I think that takes care of the bias issue. And to address this, just realistically, I mean, you argue it very well, but the point is, since you don't know who actually, well, no one precluded the person who received said email from coming in and explaining how they interpreted it. This court can't make an advanced determination of how a reasonable person from a factual standpoint do that. They're the triers of things. I'm the trier of law. When I look at it from the legal standpoint, it gives you each opportunity to do your distinguishing as you wish to do your distinguishing, ask the questions that you need to ask, and the limitation with regards to him not trying to, he's not going to be able to go through his own symptoms. A factual statement that this is accurate, he's in hospital, whether it's 1 week or 2 weeks, fine, but he's not going to go into, he felt this pain, it was exorbitant pain, it was.
I advise you of that, Your Honor.
Okay, so that's the court's ruling. Do you all want to address the bias issue? Are you all, as long as you have the ability to do so if you wish to, does anyone need any clarifications on that?
Joel Odou, I believe we understand, Your Honor, that if we choose to, we can. Joel Odou for Real Water, sorry, I was not speaking on this, but we understand the court's ruling that if we need to ask him about bias and his personal lawsuit, that we're committed to do that, but we're not going to go very far.
Right, that's correct. Counsel for ETP?
Yes, Your Honor, I understand the court's ruling.
Right, you understand bias is optional.
It's optional.
Yeah, right. Actually, all your questioning is optional, right? Literally, but I'm just saying, let's not including that in the ruling. I'm just including that gives, I think, addresses the issue. Counsel, do you need to speak to the witness for a moment?
Can I talk to you, Your Honor?
Sure.
Your Honor,
2 seconds. I'm sorry.
Briefly, since we've got an agreement that this is not going to apply to ETT, I would request a stipulation if council's willing to provide that.
I don't think a stipulation would be appropriate at this point, Your Honor, just
Mr.
because I
Kemp.
want to see what.
Mr. Kemp, we need you near. I'm sorry. Appreciate it.
Your Honor, I would consider a stipulation with counsel at the end of the close of evidence as to these complaints that come in, Because I think some of them, clearly like this one, didn't go to ETT. I think I could stipulate to that. But I think we should wait until the end and see what complaints come in and what don't. Just have more of a global situation.
Okay, does that address your question?
Well, we'd like it now, but if he's not willing to, I can't force
Are
counsel.
you saying, you're precluding ET&T from setting forth that it's agreed among all the parties that this,
No, they should, even if I did stipulate, they should go up there and say this didn't go to Terrible Herbst. Even if I stipulate that, they should do that, I think.
Yeah, I understand what he's saying,
okay, so at this juncture, if there's not a stipulation, then it's not a ruling of the court, so
Okay, thank you, Your
I
Honor.
appreciate it, thank you. So you're gonna tell the witness, Marshal, you need the marshal a second to start bringing the jury down the hallway before you go
Okay.
talk to the witness. You may wish to do that, unless you wanna have the jury see you
No.
talking to a witness right before they go on stand. Okay, thanks. I mean, you can feel free to peek your head out in the moment, it's just, he's gonna line them up, you're gonna be taken down the hallway. That's one of the other reasons why we have our jury come down the hallway and come up, not only for the ease of not you doing that, but also it's not the first or last time that people have to talk to witnesses. Okay, so Mr. Walter's binders, just not for this witness, does someone want to put it on the back shelf?
to pull it down, Your Honor?
We can put it in the back shelf if you want to, just so you don't have confusion if he starts looking through something. No worries.
So, Your Honor, while we got a second, I think we found some good news out, based on my conversations with Ms. Rojas. Because we're taking a lot of her witnesses in our case in chief, that's going to reduce the number of witnesses she has remaining. I think she said maybe 2 or 3 at the most. So that should save us some time.
Sure, so we can discuss what you all want from a time standpoint, towards the end of the day.
Sounds good.
Yes, Your Honor, Ms. Parker's correct, we did discuss that. I do have one witness issue for an expert. I've got to choose between Monday and then the following Tuesday, which would be the 13th, from what I
Well,
understand. We'll talk.
you're not precluded from the 6th, that was just a proposal as an option. Remember, if somebody's saying that they need to have a witness on that day, then of course the court's gonna consider that, right? It's just, was that an option, good day, so that you all could address jury instructions and other issues, but I'm not gonna impact somebody's witness availability.
No, he's not available on Tuesday anyway, Your Honor.
Oh, okay.
Tuesday, Wednesday, he would be out, and then he wanted to come Thursday, but we're dark, so
They've already been done for
Yeah.
Thursday,
I'm trying to work him in either Monday or the following Tuesday. is my plan.
And we will be amenable to her working in on Monday, Your Honor. As long as we're at that point. We're not going to, if she has to take somebody out of order, just like we're doing for real water, we'll do the same for ETT. We should be done hopefully by then.
We'll consider that.
Sure, well, make sure everyone has opportunity to fully down on the cases, all the witnesses.
All right, thank you, everyone, for standing. Come on in, folks. Your Honor, all members of the jury are present, and everyone please be seated.
I appreciate that, Jeff, welcome back, everyone, hopefully you had a nice lunch. Rumor has it there was decent, nice weather outside, I heard that, I got to see it from the hotel. Okay, so at this junction, we're still in plaintiff's case in chief, so now I ask counsel for plaintiff, would you like to call your next witness, please?
Yes, Your Honor, ladies and gentlemen, I'm presenting a super quickie witness. Super quickie, then I'm going to turn it back to Mr. Parker. So and this is out of order just for convenience of the witness. This is going to be real quick. I would call Steve Wadkins, please, Your Honor.
Thank you, and while the marshal's going and get, here, court coming to, so ladies and gentlemen, it happens all the time, just for convenience and things. Sometimes we might fit a witness in, and then we'll recall a witness that was previously on the stand, okay? Doesn't, take no note of that, anything other than, it's really expedite things, go ahead, then.
Okay, remain standing, face the court. Clerk, raise your right hand.
You do solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain of the penalty of perjury?
Yes, ma'am.
May I have a seat? Please state and spell your name for the record.
Steve Wadkins.
Spell it, please.
Oh, I'm sorry. W-A-D is in Delta, K-I-N-S.
Mr. Watkins, good afternoon.
Good afternoon.
Mr. Watkins, did you drink real water?
I'm sorry.
Did you drink real water?
Yes, sir.
During what time period?
2015 and 2018.
And what type of real water did you drink?
I ordered bulk.
the 5 gallons?
Yeah, the 5 gallons.
Okay, and you had home delivered?
Yes, sir.
Did there come a time when you went to the hospital?
Yes, sir.
What time period was that?
It was around May 2018,
And how long were you in the hospital?
over a week.
And what did the doctor tell you with regards to water?
Objection here, sir.
Don't drink
Sustain,
the
hold
water.
on a second. Sustain with the way that question, the way that was phrased.
Okay. Did you have an understanding as to why you were in the hospital?
Well, the doctor told me to stop drinking
Okay,
the water.
Objection, no response, sir.
thanks. Okay, the court's gonna have to stop the witness at this juncture because the court just made a ruling with regards to sustaining it. So the question asked was proper, but the answer went to where the court had just previously made a ruling. So Councilman, do you mind re-asking the question? Go ahead.
No, I'm trying. You got out of the hospital, correct?
Yes, sir.
At some point, did your family advise Real Water that you'd been in the hospital?
Yes, sir. Via email.
Remember, I moved to mid-71 during the time?
Objection, relevance.
Join objection relevant under the criteria. Hearsay.
So can you all approach Madam Court Attorney, I'd like to fix it. Those objections and joinder on relevance, court overrules those objections. Just done.
Thank you, Your Honor.
Are outside the presence.
That's 71.
Hold on a second, let me, so yes. Overruled the objection, you sought to admit,
71.
proposed 71 is now exhibit 71 over the objection to ETT and Real Water. Appreciate it, thanks so much.
Your Honor, can I show the documents for this?
Yes, you may.
Shane, can you pull that up, please? 71. Last page, Shane. We'll just skip to the last page. Mr. Watkins, is that the email you were talking about?
Yes, sir.
Okay. And thank you very much. Okay, that's it.
Appreciate it. So now, cross-examination, Real Water, do you have any cross-examination?
Good afternoon, Joel Odou for Real Water. How are you?
Good, Joe.
Nice to see you. Just 2 questions. You have your own lawsuit against Real Water, isn't that correct?
Do I have my what?
You have your own lawsuit against Real Water, correct?
Yes, sir.
And Mr. Kemp is your attorney.
Yes, sir.
Thank you very much, Mr. Watkins.
Appreciate it.
Oh, with the, don't leave just yet, there may be something else.
ETT. ETT, questions for this witness? Cross-examination?
None, Your Honor, thank you.
Counsel redirect?
No, Your Honor.
Okay, appreciate this witness. Is this witness excused for all purposes?
Yes, Your Honor, thank you, Mr. Watkins.
Yes, all purposes, counsel?
Yes, Your Honor.
Yes, Your Honor.
Appreciate it, thanks so much. Watch your step on the way down. Witness is excused, thank you so very much. Okay. All right, the parties, we're going back to the prior witness, Mr. Walters.
Yes, Your Honor, Joel Odou for Real Water, we agree.
Thank you. So Marshall, can you please get the prior witness? Appreciate it, thank you so much. All right, back to your work, go ahead.
Go ahead.
Ladies and gentlemen, the jury understand why we don't have you come in between counsel each time. That's why we actually have you come down that back hallway. So it's a little easier than some of the other.
Good afternoon, Mr. Walters.
Mr. Park, just one quick second. You understand you're still under oath, even though we had lunch break, correct?
I do.
Appreciate it, thank you very much. Now, Mr. Parker.
Thank you, Your Honor. Good afternoon, everyone.
Good afternoon.
Hope everyone had a good lunch. Mr. Walters, I hope you had a good lunch as well. I want to continue on, and I want to have Mr. Godfrey put back on the screen. I'm sorry, not on the screen. I want you to take a look at 2384.
Books are not up here.
Oh, they're behind
We
you.
put them behind you.
We didn't
because
use
there was
the
an
other
intervening
witness. Now, can I approach and let them know which binder we're looking at?
Sure, it's one of those times, of course you can.
So if you could go to document TH 2384. This is the June 10, 2019 email from Mr. Randolph to you related to the Real Water July and August promo. You see that?
Yes.
And again, it's asking for your approval of the 2 for $3 promo. You see that?
Yes.
That's what we talked about right before we left. The continuation of this email says, Nevada Beverage will sell the 1 liter cases to you for $13, plus Real Water will provide an additional $1.50 per case, and Nevada Beverage will deduct from us. You see that?
Yes.
Okay, and then finally it says, basically, your cost during the promotional months will be $11.50. We would also like to start back promoting on the pumps. Do you see that?
Yes.
To you, Mr. Walters, that's an indication that Real Water was on your pumps, correct?
Yes.
If you could go to TH 2406, please.
Got it.
Got it? Now, this is actually a 2-page document. Are you familiar with the name Amy Jones?
Yes.
Who's Amy Jones?
Do not know her title.
Okay, is she a representative of Real Water?
Yes.
Is she in fact the wife of Brent Jones, the president of Real Water?
I am not aware.
Okay. How do you know her?
Just from this email.
You recognize the name, and her email says drinkrealwater.com, correct?
Correct.
All right. And in this 2-page email to you and to Brian Breeden, she's asking for her commercial to be put back on the pumps. You see that if you go to the second page, 2407, dated July 2nd, 2019. Amy says, I would like to touch base with you and see if there's any opportunity to put the Real Water commercials on the Terrible Herbst gas pumps again. Do you see that?
It looks like it was addressed to Brian Breeden, but not me.
Okay. And then you'll see the page following. You see your name on the next page, 2406. Is that
Yes.
true?
Yes.
All right. And then she again sends another email to Brian on July 8th, so 6 days later, saying, I hope you had a great 4th of July. I just wanted to follow up and see if you had any opportunity to determine if there's an opportunity to get Real Water commercial on the Terrible gas pumps again. You see that?
Yes.
And then the response is 2406, where Brian tells her, unfortunately not at this time. Do you see that?
Yes.
And you're included in that email. Do you know why you were included in that email?
Because Brian and I would discuss the opportunity on pumps.
All right. So at least in July 2019, you were made aware by Brian of Real Water trying to get their commercials back on to the Terrible Herbst gas pumps, correct?
Yes.
All right. And in fact, if you look at 2407, there's a link to the commercial. You see that?
Yes.
Did you ever see any of the commercials?
No.
Not one of them.
Not one.
So did Brian Breeden approve those commercials without you?
It looked here like they weren't approved.
Well, they weren't approved again,
Correct.
but before, when they were running,
I wouldn't know if Brian approved them or not.
okay, he would never come back to you and seek your approval for the commercials.
He would, but not to my knowledge at this point.
Okay, so you don't know about them running before this email, is what you're telling me?
Correct.
All right. So let me have exhibit 200. I believe that exhibit has been, there's no objection to exhibit 200. Don't put it up yet, Stan. And as a matter of fact, I think that this is one that has been determined to be in this.
Yeah, so this is proposed 200, so.
It's a video you playing without sound or with sound?
I don't remember this one has sound. I think this one has sound. This is the one with Amy Jones.
Does have audio.
Real Water has no objection.
ETT,
We have an objection on relevant.
sorry, I didn't hear, you kind of, I didn't hear your microphone, I couldn't hear you.
Relevant.
Since I have, sure, come on, approach guns, approach guns. So the relevance objection by AT&T is overruled, just follows the court. Okay, counsel,
Could you play this?
And do we have permission to play with audio?
Yeah, I believe so.
I'm not hearing objection to the.
Yes, from real water, Your Honor. Bill will do.
Yes, from the TTO.
Okay. Okay. Thanks for the question, Mr. Dodson.
I don't hear any audio, Mr. Godfrey.
Are you feeling sluggish, old, and tired? It could be because your body is dehydrated on a cellular level. Most purified waters are acidic, and as a result, may be rejected by your body. But it doesn't have to be that way. Real water is different. It is beyond alkalinity. Real water is infused with negative ions for ultra-cellular hydration. You will immediately notice the smooth, clean taste as you start hydrating the minute it hits your mouth. Real water. You will taste and feel this difference.
Mr. Waters, have you ever seen that document? That commercial, I'm sorry?
No.
So that commercial, if it was approved, it would have been approved by Mr. Reed without your knowledge?
Correct.
And counsel, we just have a point of clarification, because just the exhibit number that was admitted based on a prior court ruling.
Yes, I believe that's exhibit 200? Yes, no, 200.
I think for sure that's the number.
That's what we show as well, Your Honor.
Your Honor, my next exhibit, I believe, is the other one, 11283. Which would be exhibit 199, I believe. Is that correct, Mr. Carter?
282.
282. So we just played 283. I believe this is 282. 11282.
So exhibit 200, just ladies and gentlemen, previously there were certain things that had date stamp numbers on, you see on some of the documents. Now they have exhibit numbers, so we're just ensuring that the cross-reference is correct realistically. So we've got a nice clear record. Okay, so exhibit 200, which was previously dates 11283,
That's
correct?
correct, John.
So that had been admitted by prior court ruling. Okay, thank you so very much. You're now going to,
We're going down to exhibit 199. That's correct, John.
and that was dates.
11282.
Thank you so very much.
Thank you.
Admitted by a prior court ruling. Is there anything in? Okay.
Joel Odou for real water. I believe this would be the next one, correct?
This, well, it's the USA contestants.
Okay, counsel, can you all approach Madam Court Reporter, tell what going? Okay, so the white noise is off. I believe, is there gonna be an objection to dates 11/282, which is proposed, which is exhibit 199,
Yes, same basis as the last year.
which is,
What relevance?
okay, no worries, okay. The relevance objection is gonna be overruled because pursuant to a prior ruling of the court, 11/282, which is now referenced as exhibit 199, is admitted by that prior ruling. Thank you. You may show the video.
Thank you. Mr. Carter.
Transform your body with real alkalized water. Real water is so advanced, it's beyond alkalinity. Real water is alkalized antioxidant water infused with negative ions. Maximize your body and mind's performance. And with a clean and refreshing taste, no other water can compare. It's no surprise that elite athletes and Hollywood's brightest stars choose real water. So do your body a favor and get real. Drink real water. You will taste and feel this difference.
All right. So you don't recall seeing this video either? This is something else you believe Mr. Reedon would have had to approve?
Yes.
Good. I believe we've agreed to exhibit 39.
court record shows proposed, so there's no need from the parties, the court just.
Joel Odou for real water, we have no objection to the admission of exhibit 39.
No objection, Your Honor, for ETT.
Then 39 is in, so there being no objection, counsel can post it, you can post it.
Yes. So have you ever seen this character?
I have.
Is that the Terrible Herbst character, I guess?
Yes.
All right. And you recognize that this is Terrible Herbst social media?
Yes.
And it's on TikTok, correct?
Correct.
And this was as of October 23rd, 2020. You see that?
Yes.
Would you agree with me that someone from Terrible Herbst had to approve putting this on its social media platform?
Yes.
And you can blow that up, the picture up a little bit more. And you can see the real water in the background.
Yes.
And if you could go to exhibit 38, before you do that, Shane, let's make sure we got approval on 38.
It's proposed.
I believe it is, John.
No objection from real water to exhibit 38.
Objection relevance, Your Honor.
Okay, since there's an objection, then at this juncture, council's appropriate foundation with regards to exhibit that.
Would you like me to approach one?
I
Or
don't,
want me to lay the foundation on this? I didn't hear the.
so there's an objection for relevance by one of the parties, which means it won't be stipulated in, so establish the process with regards to exhibit, please.
No worries, Your Honor.
Thank you so much.
You're familiar with Real Water having, Terrible's having an Instagram social media account as well?
Yes.
You're also aware of the fact that on its Instagram social media, that it promotes its products?
Yes.
Were you aware that Terrible Herbst on its Instagram platform promoted Real Water?
No.
Have you seen any of the Terrible Herbst Instagram promotionals on its on Instagram? I'm sorry.
I follow them. I've seen a lot of them, yes.
And so if we were to show you a picture or a snapshot of Terrible's Instagram promotional on Real Water, would you be able to identify that as Terrible's?
Yes.
All right, I'd like to show exhibit 38.
Just a second. Hold on, counsel, it's being made, I have to hear it. Are you seeking then the admission?
You're gonna, I'm sorry, I didn't hear, are you showing it to the witness to identify it, or were you
Yes.
moving to admit it?
I was moving to admit it. and I'm
I
gonna-
still have no objection to the admission.
No objection, Your Honor.
Okay, there being no objection, it's admitted and you may show it.
Thank you. Mr. Godfrey? Thank you. And so, Mr. Godfrey, can you blow up the header, all of the full header at the top? Can it get any bigger? There we go. So this was captured November 30th of 2023, a couple of months ago. You see that? So as of that date, you were still promoting Real Water on your Instagram account. Yeah, that's Instagram. Yeah, your Instagram account, correct?
I mean, it looks like that's when it was captured, but it looks like it was posted in 2020.
All right. So from 2020 all the way to 2023, this was still on your Instagram account?
I don't manage the social accounts.
Okay, you don't manage it. Who manages it?
Brian Brady.
Thank you, Brian. Got it. And would your answers be the same if I were to point out to your Facebook social media platform?
I don't manage the content.
That you'll be able to recognize it if I was put on the screen, sir?
Yes.
Your Honor, I move for exhibit 34 as admission. So actually, let me make it easy so we can do it all at once and trade it on. 34, 35, 36, and 37 are all Facebook social media promotions.
Joel Odou for real water, no objection.
I'm just subject to my prior objections with regard to these.
Okay, counsel, I need evidentiary basis each question by question?
Relevant, Your Honor, on all of them.
On all of them, okay. Counsel, please follow appropriate process with regards to.
And Your Honor, I asked the witness before the objection that his answers would be the same in terms of being able to identify the social media platform on Facebook as to Terrible Herbst promotions of real water. He said he could if I put it on the screen, and.
One by one, counsel, please.
I'm sorry.
One by one, counsel, please.
Sure.
So the court can evaluate each one.
Sure.
Thank you.
So, Exhibit 34, Your Honor, is the first, and again, it's a Facebook social media promotion by Terrible Herbst of real water. That's the first one we're asking about. And each one of the others I'm asking about is the same.
Counsels, would you like to approach, please? And also state at bench the objection on relevance.
I moved out in the world.
Well, next thing you know, everyone's gonna want my chair. It's all good. Okay, so, for as far as the court's ruling, proposed 34 is admitted for the reason stated at bench. Proposed 35, admitted for the reason stated at bench. Proposed 36, admitted for the reason stated at bench. Proposed 37, admitted for the reason stated at bench. All over the objection of ETT. So counsel, they are admitted.
Thank you.
And there being no objection by real water. Thank you.
Thank you, Your Honor. Mr. Godfrey, can you put up 34 just for a couple of seconds? I just want to show the picture, describe it, and then we'll go to the next one. Mr. Walters, do you recognize this is Facebook's, a Facebook promotional or at least posting by Terribles on this platform?
Yes, it looks like a Facebook post.
And you can see real water in the water, in the frozen, or not frozen, but the coolers here.
Yes.
All right. Go to the next one, please.
Counsel, can you independently identify when you're going switching from?
Oh, I'm sorry, Your Honor.
Thank you, just.
Mr. Godfrey, can you go to Exhibit 35? Again, Terribles is promoting several beverages there, real water included. Is that correct, Mr. Walters?
It looks like it's promoting AHA. The real water's in the background, yes.
Okay, good enough. Next one, please. 36. Exhibit 36. Again, Terribles promoting real water, correct?
Yes.
All right, and then 37, please, Mr. Godfrey. Is that again another example of Terrible promoting real water?
Yes.
Thank you. Now, if you could go back to the other book. So just to keep you on track, we've talked about 2010, 2016, 2019, now we're in 2020. And some of those social media posts were in 2020 as you referenced, is that correct?
Yes.
All right. I want you to look at date number 2357. This is an email dated February 5th, 2020.
357?
Yes, sir, 2357. The top is an email from February 5th, 2020, and right below it is an email from Anthony Randolph to you dated January 28th, 2020. Can you see that?
Yes.
So this is just a little more than a year and a half from the time you were asked by Mr. Kemp about any communications, is that correct?
Correct.
All right. And at this point, Mr. Randolph is asking you about additional promotional opportunity to Terrible Herbst for real water, is that correct? And if you want, you can take a second and read through it.
Question again?
This is an email from Mr. Randolph asking about promotionals that Real Water can get involved with Terrible, correct?
Correct.
And in fact, in the second paragraph, or the first paragraph, Mr. Randolph comments about Mrs. Herbst liking Real Water. Do you see that?
I do see that.
And then in the second paragraph, it mentions that Real Water was once featured at the pumps. Do you see that? Last sentence, second paragraph.
Yes.
And on the final paragraph towards the bottom, it says, "Thank you for all your years of supporting Real Water." See that?
Yes.
And by that time, and based upon the social media, you've been selling Real Water and dealing with Mr. Randolph for over 10 years, correct?
Yes.
And when Mr. Kemper asked you about communication, you didn't remember any of that 10-year period in terms of communications.
Again, this email came from Ken Rathel at Nevada Beverage because I didn't reply to Mr. Randolph's. We typically deal with the supplier, the wholesale distributor, Nevada Beverage, and have more frequent conversations with them.
Okay. But this email came to you from Mr. Randolph, correct?
Yes.
Go to 2404. Now, this is an email from Mr. Randolph to Mr. Breeden, but it references a meeting that Mr. Randolph had with you in February 11, 2020. Do you recall meeting with Mr. Randolph in February, actually sometime in February 2020? This says February 11th. It must have happened before then, or maybe the same day.
I don't recall.
It says, "Hello, Brian. I met with Mark Walters yesterday." So that'd be February 10th, correct?
Correct.
"And we would like to set up time for you and I to meet to discuss the marketing opportunities you have available." Do you remember meeting with Mr. Randolph about marketing opportunities in February 10th, 2020?
I do not.
If you could go to 2418, please. Let me get that in.
2418?
Yes, sir.
I'm here.
Okay, good. This is November 13, 2021. So about a year from the time, the year before you spoke to Mr. Kemper about communications. You see that?
Yes.
And it's an email, the top email is from Mr. Randolph to Mr. Breeden, but the email in the middle is from Mr. Breeden to you, dated November 13, 2020. You see that?
Copied me, yes.
Okay, good enough. And you're being copied on Mr. Randolph's appreciation for all the support from Terrible, is that correct?
This is, the subject is BP 21 marketing presentation. This email went to numerous people,
But
over 100 to be accurate.
that's fine, the Real Water was included, correct?
They were one of the 100, yes.
So, one more, I want you to look at 2346. And this is actually, the subject of the email is the 2021 Supplier Partner Marketing Meeting. See that?
Hold on, 23 what?
2346.
Yes.
And at this point, you're the organizer of the meeting, correct?
Yes,
Says organizer Mark Walters, correct?
correct.
And Brian Breeden is required, one of the required attendees, correct?
Correct.
And then in terms of optional attendees, the third on the list, or the second on the list, I'm sorry, is Anthony Randolph, correct?
His name is spelled incorrectly, but yes,
All right. And he's identified as one of Terrible's supplier partners, correct?
with that list, yes.
All right. Now, with all we've gone over, I want you to compare that to your declaration. You recall preparing a declaration in this case?
Yes,
Do you know why? Again, I don't want you to discuss anything that may come from an attorney, but outside of that, do you know why you were preparing a declaration?
No,
Okay.
obviously for this case.
All right. And do you know why it was needed in this case? Again, I don't want to know if it came from an attorney.
I do not know.
And right before we get there, you talked yesterday about 2 searches that were done. First search was your email, is that correct?
Correct.
And then the second search was roughly a year later. And you said it was also November, well, 2 years later. One was in 21, the other one is November 2023. Recall that? All right. And when you did that search, did you also search your email?
When I did the search in 23?
Yes, sir.
Yes.
All right, did you search anything else?
No.
All right, good enough. Now, let's go to your declaration. And Your Honor, this is Exhibit 7, I believe. Let me make sure.
Not seven.
Your Honor, it's not in Exhibit 7.
Hold on a second. We were about to say that, okay?
Yeah. It's in your book. Your Honor, may I approach? Tell me which-
So, hold on just a second. So it's not a proposed exhibit, it's not an exhibit, so,
I'm gonna have him use it for purposes of this discussion, Your Honor. I don't know if we've actually identified it as an exhibit.
Counsel, can you all approach, please? Okay.
All right, Your
Some of our
Honor.
chairs are older and some of them are. Actually, you guys have comfortable chairs right now, so. Okay, counsel, you were proposing something before we
Yes,
bench.
Exhibit 526, Your Honor, would like to move into evidence. I need to show him where it is in the.
Sure, but let me hear from each of the other counsel, Bill Water.
Joel Odou for Real Water, no objection.
Dan Dover for ETT, no objection.
Appreciate it, thank you much. Yes, you may approach, yes, you may show witness.
Thank you.
I think it's already up on the screen too. Counsel, did you want it up on the screen?
Yes, please. You're welcome. So, Mr. Walters, what we have in front of you, both in hard copy and electronically, is a declaration that you signed, is that correct?
Yes.
If you look at the last page, Mr. Godfrey, is that your electronic signature?
Yes.
And it appears that you signed it November 21st, 2023, correct?
Correct.
And that's about the same time you did your second search, correct?
Yes.
Now, this declaration, you have an understanding, not relying on counsel, of course, for ETT, or Terrible. Do you have an understanding of why you were being asked to prepare a declaration?
Yes.
And can you explain to the jury why?
Supporting our,
Objection, Your Honor. Oh,
Extended.
I'm sorry, I was trying, go ahead.
Okay, switch on, witness name, thanks,
Go right ahead, sir.
so it's there in support of the plaintiff's motion to strike ETT 1.
So you are opposing plaintiff's motion. It says opposition, Terrible Herbst's opposition to plaintiff's motion to strike.
Yes.
All right. And so you were doing it in support of Terrible's, correct?
Correct.
And it identifies on page 1 here that you're the vice president of purchasing and sales for Terrible Herbst, correct?
Yes.
Since 2006. And you further say, I have personal knowledge of the facts asserted herein, and if called as a witness, which we're lucky to have you here as a witness today, I can competently testify thereto. You see that?
Yes.
All right. Did you have an understanding of what that meant, that you could competently testify to the information in this document?
Yes.
What was your understanding?
That I can speak to what I wrote in the declaration.
All right. And when you signed this document, you did so under penalty of perjury, correct?
Not at the time.
All right, well, let's show you the last page of this document. There we go. Let's highlight the last paragraph right above your signature. It says, I declare under penalty of perjury, under the laws of the state of Nevada, that the foregoing is true and correct, and that this declaration was executed on November 21st, 2023. You see that?
Yes,
When you sign this document, were you in fact, based upon what we've discussed here, giving false information?
no,
Is that information in this document been proven false?
yes,
All right, so let's go through it. Paragraph 2 says, I have reviewed plaintiff's motion, and in particular the accusations that Terrible Herbst, Christopher Kemper, and Brian Breeden falsely stated. Number 1, Terrible Herbst did not have communications with Real Water employees in 2018, 19, and 20. You see that?
yes,
So when the plaintiff actually said that, the plaintiffs were correct, based upon the documents we found. Isn't it true?
found after this was signed.
So that one was correct. Plaintiff was correct about that. Let's go to number 2. Terrible Herbst did not have any agreement with Real Water. Now, we've seen, up to now, sir, promotionals, pricing incentives, we've seen social media, we've seen commercials, we've seen coupons, correct?
Yes,
And we saw emails and letters regarding pricings for cases of water, correct?
correct,
Even if you don't have a, let's say, a contract, that was an agreement made between business people, correct?
correct,
Thank you. Then number 3, it says Terrible Herbst did not run Real Water video advertising on his pumps in 2019 and 20. Well, you did find the coupons and the foreign pump information in 2020, correct?
after the declaration was signed.
All right. Now, let's keep going. Now we'll go to paragraph 4. I conducted my searches of emails and hard drive. Do you see that?
Yes,
When you testified yesterday and today, did you ever mention to this jury in response to my questions that you checked your hard drive?
no,
But you said this in the declaration, correct?
correct,
And you still didn't find me.
no.
So yesterday when I asked you what you searched for, why didn't you bring up the hard drive?
Technical term that, I mean, I wouldn't know how to search my hard drive, I know how to search my computer.
Okay, so, but now you say you did check your hard drive.
I would assume that means the computer.
Uh-huh. All right.
So a friendly reminder, remember ahas and ahs.
I'm sorry, Your Honor.
Yeah, no worries, people say it all the time, we just get a nice clear transcript, thank you.
Understood. I should have said understood, Mr.
No worries.
And I did not locate any communications or agreements between Terrible Herbst and Real Water. See that?
Yes,
So between November 21st, when you signed this document, until January 17th or 18th, once we already started trial, is when you decided to search a different way and discovered all these documents, correct?
the chief information officer assisted me to search my computer and emails, yes.
It says here, I did locate an email with Nevada Beverage about the recall. But that communication was directly with Nevada Beverage and did not include Real Water employees. Do you see that?
Yes,
Now, today, we've looked at emails that included Real Water and Nevada Beverage, correct?
correct.
So if you found something with Nevada Beverage related to Real Water, why didn't you produce that? Strike that. Why didn't you inform Mr. Kemper of that back in November 2021, November 2023?
The recall letter was already produced.
Did you, when you were searching for items or communications with Real Water, and if they involved Nevada Beverage, you could still inform Mr. Kemper about that, correct?
Yes,
Right. And we've discussed now emails that actually involve Nevada Beverage and Real Water, correct?
correct.
And you couldn't find any of those?
No.
Let's go to paragraph 6. I spoke to Christopher Kemper, Terrible Herbst Executive Vice President of Administration before his deposition. Do you know he was being deposed?
Yes,
Okay, and do you know why you met with him before his deposition?
to answer questions for his deposition.
Okay, do you know why you were meeting with him?
No.
Did you ask for that meeting, or did he ask for that meeting?
He asked for me.
Okay. And it says here, I advised Mr. Kemper of my computer searches and the fact that I'm not aware of any communications, agreements, or contracts between Terrible Herbst and Real Water. When you met with Mr. Kemper before his deposition, did you describe to him at that point any of the stuff we've discussed today? The promotionals, the coupons, the commercials, the price points, marketing, anything?
Talking about where we purchased real water from and that we did carry the product and we sold the product, yes.
That's it, nothing else.
Did not get into detail, no.
Which means if he was asked about the details, the only information he could give is what you gave, correct?
Unless there were other email searches provided to him.
Yeah. Paragraph 7. I spoke to Brian Breeden, Terrible Herbst Vice President of Advertising and Marketing, before his deposition. I advised Mr. Breeden of my computer searches and the fact that I'm not aware of any communication, agreements, or contract between Terrible Herbst and Real Water. The emails we went through before lunch and after lunch involved Mr. Breeden and you, correct?
I was copied on one of them, yes.
And when you spoke with Mr. Breeden, did Mr. Breeden remember any of these emails?
He didn't come up with any of his search as well.
So both of you, after all of these emails, couldn't think of any communications you had with Real Water, despite everything we've seen today?
Yes.
Okay. Let's go to paragraph 8. I do not recall Terrible Herbst running any videos or commercials of Real Water on his gas pump and digital monitor. You see that?
Yes.
Would you agree with me that your declaration was again false, and that now we've seen over the last couple of hours commercials, gas pump related marketing materials, all of those things, correct?
We've seen them on a search after I signed this document.
Right, making this paragraph false as well, correct?
After I signed it.
Yes? It says, I reviewed 3 videos produced by a plaintiff that promote Real Water, including 2 videos that are 30 and 2 31-second long. One video that is 18 seconds long. I do not recall ever seeing these videos before. And when you met with Mr. Kemper, did you tell him about those videos?
No.
You understood when you gave that declaration, you were supposed to be doing it as if you were sitting here in court of law, correct?
Yes.
Understood. You know, let me check with my colleagues, but I think I will pass the witness in one. Well, we've got 2 thumbs up, Your Honor. I think we're done with Mr. Moore.
Cross-examination by Real Water.
Hey, John, Joel Odou for Real Water. We don't have any questions.
Okay, thank you. ETT?
Yes, Your Honor.
How did you become aware of new documents within the past month or so?
I had a conversation with Brad Sexton, our Chief Information Officer, that talked to me about an online archive folder where older emails have been stored.
And were there searches, as much as you have learned, done before by the IT department and not just searches by you alone?
The IT department was, I believe, who was doing the original searches.
Now that you've had a chance to look at all the documents in the case up to date, everything you've seen, everything that's new, old, whatever, all of the documents, including everything in front of you, have you ever seen any document between you and Real Water, or you and Nevada Beverage about Real Water, that's anything other than what we would call pricing or promotions? We'll give you so much for a bottle, let's run an ad, things like that.
No,
And do you do pricing and promotions with all of your customers? The vendors that actually you'd be the customer, but vendors that sell through Terrible Herbst?
all of the products that are in the store, yes.
Okay, so are there Anthony Randolphs for Pepsi and for chips and for everything else that we would go to and purchase in a store?
There are broker representatives, there are supplier representatives, and manufacturer representatives, yes.
So to the extent you have, Anthony Randolph is somebody that you did meet with and know over the years, right?
Yes,
And you met with him a couple of times, few times, whatever, individually, and then other times you'd meet with him like the one document that we heard of that hit 50 or 100 people, whatever it was, in one meeting.
yes, if you look at the BP meeting, that's business planning, and then we'd meet with majority of suppliers, yes.
So when he's meeting with you once or twice a year, even some of those meetings are gonna be meetings with 20, 50, whatever, 100 people at a time.
Yes,
And would they basically be in the same position that Anthony at all these other companies?
Your Honor, that causes speculation, and he's leading, Your Honor.
Okay, I sustain it on leading, and then overruled on speculation, let his proper statements.
Would you tell us about the group meeting? Remember you were asked a question and you said, is he on, was he number 2? And you said, yes, it was either 50 or 100, I don't remember what the term was you used. Tell me about that meeting, for example.
so the meeting that we were referring to that was BP 2021 is a business planning meeting that Brian and myself run and review all the marketing opportunities to the potential supplier partners that are in the stores. And in a group setting, there could be 50 people on that call.
Okay, and since COVID, have you done any of those on Zoom?
That's where those were held, were Teams or Zooms held.
And before COVID, did you tend to do those kind of meetings on group calls with everyone?
It would be group calls, yes.
Do you have other Anthony Randolphs, meaning people in that promotional end from the people that want to get, so Anthony, let's start, let me withdraw that, Your Honor. Anthony's a salesperson for Real Water, and he wants to get product in the store and try to get as much volume as possible, right?
Yes.
And is that similar to what all the other salespeople for all the other products in the store do?
Yes, there's representatives from Miller Coors that meet with their distributor in a group setting to get products and promotions in the stores.
How many emails do you get in a day approximately?
The last time I was on the stand, I said well over 100, and that is very accurate, well over 100 a day.
And about what percentage of those are people writing you pricing and promotion like things as we're hearing about all the documents from Anthony Randolph?
There's a good 20 a day that are about pricing or promotional activity.
And do they sound much like these? Can I do a pump and pour, or can I get my videos on, or can I run a special price for you 2 for 1, or I'll offer a free product, that kind of thing?
There's a wide variety of emails, but yes, a lot of them are talking about running, well, we would say promotions, but if, I think I said it earlier, anything we have in the store, if there's a price on it at 2 for 3 or a retail promotion, then we're promoting the products in our stores to sell more products, yes.
And I'm gonna get down to the specific notice of recall on March 16 of 21 with you. We'll go through that in some detail. Is that the first time you became aware of any alleged health issues or any recall or not with regard to anything to do with Real Water?
Yes.
That's the first time.
Correct.
Okay. In all of any of the documents you've reviewed since then, has anything changed on that, or is that still the first March 16th of 2021? Is that the first time that there was any notice to you of an actual problem or a health risk with regard to Real Water?
Yes, March was the first notice in 2021.
Has anything that's been shown to you today or discussed with you today about any communication with Anthony or anybody at Real Water, or anybody at Nevada Beverage about Real Water have anything to do, any of these, with either health or safety in relation to Real Water?
No,
If I went and asked you for any of the other products of any size that are in the store, do you have pricing and promotion documents coming up and back like you saw today? Would you have those same sort of documents for at least most of the vendors that want to get product in Terrible Herbst?
yes.
On the pricing, so there's a couple of these that say, one was, I'll give you $1.50 off on a case, there were things like that, right?
Correct.
Then there was another one where we saw the coupons for the free drink, where if you went to the gas pump, you could either get a free fountain drink or a free fountain coffee, or you can get an actual packaged product. Is that what you call?
Packaged beverage.
Packaged beverage? You could get a packaged beverage, in other words, a bottle that's sealed.
Yes,
Okay, and in this case from Real Water, right?
yes,
So we know there was some pump and pour where when you would go to the gas pump, no matter how much gas you bought, you'd still be able to get a free, either the free fountain drinks of one kind or another, or the free packaged good, including the Real Water.
yes, there's multiple products on a pump and more.
And is there a history going back to the beginning of Terrible Herbst about offering something free with regard to gas as a thing to make your customers happy and promote business?
Yes, I've only been there, it's going on 18 years, but Mr. Herbst was known for providing free things. I think if you go back to Mr. Herbst's grandfather that started the business in the 1930s, they offered free pony rides with the fill-up. So he was the kind of what I would say pioneer of free. And there's a poster in our conference room with Mr. Herbst's father that started the business, again, way back before my time, where they gave away free bags of sugar when you got to fill up with gas. So yes, it's been part of the culture.
And by the way, in this case, for example, an individual manufacturer that wants to get product in, do they offer a promotion and tell you for a certain period of time, a month or two, that they'll give you a credit? In other words, they're providing free bottle. They're the ones that are going to provide the free bottle. But they don't do that with you directly. They do that through Nevada Beverage. Your Honor, again, he's leading. Okay, I'll withdraw that. I think he made a good point. Were all of your dealings and pricing and payment, in other words, when you got a bill and when you paid a bill for the water, did that come through Real Water or did that come through somewhere else?
Nevada Beverage would deliver Real Water and we would pay Nevada Beverage.
Okay, so let's start with the delivery part, because you said they deliver it. Would Nevada Beverage be the one that would bring the product and actually deliver it in the store?
Yes.
And who's Nevada Beverage?
Nevada Beverages, they're our wholesale distributor. They're actually one of the largest wholesale distributors for Anheuser-Busch products in Southern Nevada.
Okay.
They not only deliver non-alcoholic beverages like Real Water, Arizona Iced Tea, Essential Water, Eternal Water, they also deliver all of the Anheuser-Busch portfolio, so Budweiser, Bud Light, Michelob.
So when you tell me they're a big Anheuser-Busch distributor, you're telling me that you're just trying to give us the sense that that's a real large beverage distributor, both alcoholic and non-alcoholic, right?
Yes, Nevada Beverage, from my understanding today, is still one of the top 10% of the Budweiser distributors in the country.
Okay. And so do you actually, if Nevada, if Real Water wants to give you some concession like we see in these emails, $1.50 off for a case, okay? I take it that's to try to incentivize more sales and push more sales. So in other words, increase the volume, right?
If there's an discount on the case of product, and we
Yeah.
try to pass that discount along to keep our margin where it's at, but offer a lower retail to the consumer.
And hopefully get more sales, because it's kind of on sale or it's at a reduced price, right?
Correct.
Okay, now, did that go through Nevada Beverage, or would you deal directly with Real Water on that?
I have monthly pricing meetings with Nevada Beverage, and they submit their entire portfolio of promotions through Nevada Beverage.
Okay, so when you have a case of Nevada, a case of Real Water in the store, did you buy that, the person that you were billed for it and that you paid, was that Nevada Beverage or was that Real Water?
We purchased through Nevada Beverage.
And did Real Water actually start coming to you in the first place, trying to see if they could get in your store?
Yes.
And what did you tell them?
My response to Real Water and other folks that are looking to gain distribution of Terribles is you need to go through a wholesale supplier. We don't buy products direct.
And do you rely in part on the wholesale supplier like Nevada Beverage, who's in that specialty business of beverages, both alcoholic and non-alcoholic, to be an additional check on the products that you're getting from a safety standpoint in your stores?
Yes, we obviously rely on those national distributors or larger distributors to have a check and balance to provide us high quality product to make sure that we're providing that for our consumers.
By the way, when you answered any of the questions at any time, were you or were you not truthful at whatever you knew at the time you signed those?
I was truthful at the time that I signed them.
And on some of those where you have learned something more on the latest documents that have been turned over, has that been disclosed? In other words, that you're making those documents available, whatever it is you learned, that those were turned over. Is that correct?
Objection, Your Honor, can we approach?
You may approach, and then before you approach counsel, can you go back and say an evidentiary basis
Yes, Your Honor.
before you approach, thank you.